Slip and fall cases are often called premise liability cases. You trip and fell on someone's property, you slipped and fell on someone's property. It's a premise liability case, meaning that company or that establishment, they're liable for not necessarily keeping the premises in a good orderly condition. Common causes of slip and fall cases, that could be wet or slippery floors. It could be uneven terrain, uneven floors or surfaces. It could be poor lighting. It could be obstructed walkways. And then there are other unique situations about slip and fall cases as well. Sometimes I've even come across it where you're walking in the parking lot and you slip and fall because some of the part of the parking lot is a little bit more slippery than the others. It's because maybe they're not using non-stick or non-slippery particular paint, and that's why you slipped and fell. Some facilities may have a duty to know that the outside surface should have used certain types of non-slip paint or non-stick paint to prevent that injury that you sustained. But those are common types. Where do they happen? They often happen at retail establishments, restaurants, supermarkets, public spaces, and residential properties as well. What you may not know is that most of these businesses carry general liability policies, and they're pretty large policies because they know they have a number of individuals in the public that are traversing that, coming into the store and out of the store, and therefore they need to protect themselves and not maintain the property correctly. Some legal considerations for slip and fall cases: elements required to prove negligence or fault rather. In a slip and fall case, the property owner needs to use reasonable care in maintaining the property to prevent you or the public at large from slipping and falling. What do you do if you experience a slip and fall case? Well, first thing you do is you want to contact the employee or the manager of the establishment. You want to file an incident report. It's important that you do that. And if you're able to get a copy of that incident report, that's even better. They're not required to give you a copy in Florida of that incident report, but if you can get a copy of that, that would be great. And give that to your lawyer to look at. The next thing you want to do is seek immediate medical attention, especially if you have any injuries or any pain at the time of slip and fall or immediately after. Get checked out by an urgent care facility or your primary care doctor, or ask your family and friends for a recommendation. If it's serious enough, by all means, take the ambulance to the hospital, go to the emergency room, but definitely get checked out to make sure that you are okay, because many times people are seriously injured in some fall cases. They may have broken bones. They could have torn a ligament. They could have torn an ACL. It can be a very scary situation for you and your family. If you slip and fall on a premise, often you are embarrassed, and just know that it's not necessarily your fault. In fact, it most likely is not your fault. The establishment has some or the majority responsibility in maintaining that property. And if you have any questions regarding slip and falls and premise liability cases, myself, I'd be happy to speak with you. I'm attorney Rob Johnson with Carter Injury Law, and please give me a call and set up a time to speak with me, either in person in our office or on a phone call. It's a no-fee, no-cost consultation, and I would love the opportunity to provide you some guidance and walk you through the process.